Good morning or afternoon, depending on where you're listening from. My name is Francesca Guerrero. I'm joined by my colleague Joyce Rodriguez, a managing associate in our international trade practice. We have a lot we want to discuss today, so I'm going to go ahead and jump into the housekeeping items while people are still joining. Today's program is being recorded, and we will send a link to all attendees within 48 hours of today's presentation. If you have any questions during the webinar, please use the question box located in the control panel to the right of your screen. Just type your question in there. We will keep tabs on it during the presentation and try to answer as many questions as we can during or at the end of the webinar. We are offering CLE credit for today's webinar, so please be sure to fill out and return the webinar affirmation form found in the handout section. That's also in the control panel to your right. The form provides instructions as to where to send the completed form, and I will announce the tracking code at the end of the program. So you'll need to write down that CLE code. In the handout panel, you can also download a copy of the PowerPoint slides as well as bios of today's speakers. Again, thank you for your interest, and we will go ahead and get started so we can cover our topic. Next slide, please, Joyce. So first, we're going to briefly talk about human rights and forced labor to put the Uyghur Forced Labor Prevention Act in context. And we'll talk about the legal enforcement framework for forced labor generally, as well as the Uyghur Forced Labor Prevention Act, which I know some people call UFLPA. I haven't gotten there yet. Then we will talk about the act itself and compliance with the act. And we will move into practical considerations. You know, once you kind of digest what it requires, what does that mean for you and your company? And we'll talk about some best practices. In addition to questions, if you have some best practices to share or some interesting ideas, please feel free to put them in the question box as well, and we can highlight that. So just to put a little bit in this in context, we have some statistics from the ILO, the International Labor Organization. This is forced labor around the world. It's a huge issue in many regions and countries. And it's something that has been getting increasing attention and focus in the last, I'd say, 5 or 6 years, but has been a concern, obviously, for many, many decades. So the ILO, where we pulled our stats from, is a very useful resource if you're trying to understand what's happening with forced labor enforcement in the world, if you're trying to get some background information about where the problems are and you're doing your risk assessments. It's a United States agency for the world of work, as they call it. In 1930, the ILO Forced Labor Convention was signed by many countries, including the United States. And the Tariff Act of 1930 implements the forced labor contravention standards that they had in that convention. And so then what you'll see is that, you know, from that time forward, the United States had a ban on the importation of goods that were made in whole or part from forced labor. In 2014, there was a new protocol added to this convention, and it provided additional guidance on measures that countries should take to prevent and remedy forced labor. And so some of, you know, we share this because some of what you're seeing around the globe is developing out of this convention. Next slide. So what is forced labor? It's any labor that's performed involuntarily, meaning without free and informed consent. It's not necessarily under physical duress always. It could be psychological duress, threats to family members, or it could involve confiscation of people's papers or withholding of wages, a threat to turn them into immigration authorities or other, you know, other types of threats. We'll look at the indicators of forced labor in a second. No, actually on the slide right now. So to expand on what I was just saying, These are the ILO's 11 forced labor indicators. And it is something that when you're doing a risk assessment, when you're assessing higher risk suppliers, these are worth really referring back to, because these indicators are used by Customs and Homeland Security and other agencies to figure out if we've got forced labor that, of concern. So abuse of vulnerability, that can be like an ethnic or gender vulnerability. Other vulnerability is deception, trickery around jobs, restriction of movement, confinement or not allowing people to leave a town or city without labor, isolating people and cutting them off from their communities, physical or sexual violence, intimidation, threats against themselves or family members, keeping their papers. That's something, I dealt with in the United States, on pro bono cases. So this is something that happens globally. Withholding of wages, until they finish out a term of service. Debt bondage, where they have to pay back, like the idea is they have to pay the employer back with their service. Abusive working and living conditions and excessive overtime. So these are all the indicators that can happen, anywhere in the globe, and we'll kind of refer back to them throughout the presentation. So the legal enforcement framework. Joyce, am I taking this section? I think I am, right?
You can talk about this slide and I can take the next one.
Okay. So we referenced the, trajectory of enhanced protections, enhanced requirements since really, 2014. The California Act was sort of a predecessor as the 2014 protocol was percolating. But 2015, many of y'all will know the U.S. passed the Trade and Facilitation and Trade Enforcement Act, and that's when the customs rules were revised to remove some of the sort of loopholes that used to allow goods made with forced labor to come in and would make the standards sort of harder to meet. So in the reverse, now it's easier for CBP to claim that there's forced labor. Other acts in Europe were passed. The Uyghur Forced Labor Prevention Act was passed in 2021, focusing on Xinjiang and the issues in that region. And then we wanted to make sure we highlight the EU Directive of Corporate Sustainability Due Diligence, which is being implemented now because some of the requirements that everyone's grappling with now with the UFLPA are, we foresee as our crystal ball that these are going to be expectations that become global expectations through things like the EU directive. So, we do see this being a trend of enhanced expectations. Joyce, I'll turn it over to you.
Thanks. Yeah, no, thank you, Francesca, and thank you everyone for joining us today as we grapple with these difficult topics. And I'm glad that Francesca gave us, that context and not just in general. And I can't believe I was like, this was passed in 1930. The ILO was in 1930. It's going to be almost 100 years. So this has been a long time coming, even though we've certainly seen in the last 5-10 years, as Francesca mentioned, an increase in enforcement and legislation throughout the world progressively. As she mentioned, the Tariff Act of 1930, that's where we see in Section 307. Does it seem like it's moving around? Is the screen looking okay?
No, it went out of PowerPoint mode, presentation mode.
Okay, it's tricking me. Okay, is that better?
Yes.
Okay, great. So it started with this law that generally prohibits the importation of goods made in whole or in part with forced labor into the United States, and we'll talk about that a little bit more. And then, as Francesca mentioned, the TFTEA was enacted and severely expanded the enforcement of Section 307 through the repeal of this sort of loophole that said, even if the import is potentially produced in whole or in part from forced labor, if we don't have enough of this good to meet the consumptive demand in the US, there was an exception for that. Once that was removed, we saw a huge increase in withhold release orders, at least relative to the time period before that. And withhold release orders are how CBP Customs has traditionally enforced this importation ban by designating certain companies, certain regions, certain materials that are presumed to be produced through forced labor and are denied entry into the United States. This is the language in the Tariff Act of 1930 that you'll see mirrored throughout much legislation, not just the one we're talking about here, but just in general. And it's a prohibition on all goods, mined, produced, or manufactured wholly and in part. And we underline that because that's what makes this quite tricky. And it's in any foreign country, not just China, not just any particular country, but any foreign country by forced labor under penal sanctions should not be entitled entry into the US, and that importation will be prohibited. So as a precursor to what I will be referring to as the UFLPA, we saw a lot of focus on the Xinjiang region of China. You can see that the US government, many agencies came together and published the Xinjiang Business Advisories, initially issued in 2020 and recently updated in the summer of last year, really to warn companies not just about the importation risks with respect to Xinjiang, but also exportation risks. And it goes in there. If you haven't looked at this document, it is very, very relevant, really laying out what companies should be looking at with respect to their supply chains more generally, not just for importations, but also with respect to sanctions, export controls in the region. And this culminated in, bipartisan support for the passage of the UFLPA. It passed last year at the end of the year and just became effective June 21st of this year. I don't know why it keeps doing that. Right. So the UFLPA, which is what we're going to spend most of our time talking about, is tied, as I mentioned, to Section 307's prohibition of entry of goods into the US that is made with forced labor. Most significantly, it establishes a rebuttable presumption that all imports of goods produced in whole or in part in the Xinjiang or Zhuo region of China or involving a UFLPA entity list person are produced from forced labor. That UFLPA entity list is in the DHS strategy guidance, which we're going to go through in pretty good detail, and it's available on the CBP website. And finally, it authorizes CBP, similar to WROs, to enforce and determine exceptions to the rebuttable presumption, specifically where certain compliance program requirements are met, as well as import-specific requirements are met and set forth as set forth by the DHS. Right, the week before the effective date of the UFLPA was a busy week. CBP and DHS issued two guidance documents. The Cpp Operational Guidance was issued on the 13th of June. And it really does explain and go through enforcement operations and, most significantly, to importers, the types of documents that CBP will be looking at when importers are attempting to seek an exception to the rebuttable presumption. It provides that CBP will identify the imports within the scope, provide notifications to importers of record on the type of enforcement actions that will be taken, and they will have the power to review and determine whether to take any exception to the rebuttable presumption, or, and interestingly, whether or not the import actually falls outside completely the scope of the UFLPA. They also issued, or DHS also issued, strategy guidance on the 17th, strategy to prevent the importation of goods mined, produced, or manufactured with forced labor in the People's Republic of China. And these documents are available on their website. The CBP Operational Guidance is about 16, 17 pages. This guidance is like about 68 pages long, so it's quite the read. But what we're going to focus on today is pages 40 through 50, which goes through all of the standards that are going to be required by importers to rebut this presumption. So this specific guidance was actually mandated by the legislation, and DHS took charge of doing that to provide importers with more information and interpretive guidance on what program elements they're going to have to prove and show that their programs like actually have, that their forced labor compliance programs actually have, including due diligence, supply chain tracing, supply chain management measures, as well as the clear and convincing evidence standard, which importers will need to show and prove through documentation, as well as compliance with their program in order to show that their goods are not actually produced in whole or in part from forced labor. Did you have something you wanted to add, Francesca?
No, I was just mentally preparing for the next segment.
Yeah, so Francesca will be handling the next segment, going through all of these requirements, but we did want to just highlight that there's two ways to respond to one of these notifications you receive from CBP. One is if your import does fall within the scope of the UFLPA, you would be requesting an exception to that rebuttable presumption, and you have to show a due diligence system is in place, supply chain tracing is in place, as well as supply chain management. The DHS guidance provides some detail about what that is going to look like, and we're going to touch on those in the next few slides, as well as what it means to prove by clear and convincing evidence that they were not produced in whole and part. We did want to mention that you also have to comply by completely and substantively responding to all their inquiries. So all of these are what you need to rebut the presumption. If your position is that your goods fall outside of the scope of the UFLPA, meaning they're completely sourced outside of the Xinjiang region and they do not involve any of the UFLPA entity list persons, you have to show only one of the program requirements, but you do have to continue to trace. You do have to show sufficient information that would trace your goods outside of the Xinjiang region.
Right. And I think you made this clear, Joyce, but just to reiterate, because of the in whole or in part rules, and because of the way Customs has interpreted this, if you have a raw material sourced from Xinjiang that is transformed through multiple processes into a different item sourced from another country, it still falls within scope because of the raw material. And so they look all the way through the supply chain to those materials. And one of the questions that honestly we won't spend too much time discussing today, but one of the questions that many people have is, how does CBP or how does DHS identify likely finished goods or processed goods that are coming into the US that have these upstream sort of forced labor inputs? And a lot of the guidance, a lot of the the other pages of the guidance that Joyce mentioned we won't discuss go into how they're making those determinations. So the sort of plan for using data analytics and combing available information to try and build those connections. So we won't talk about that process, but that is happening in the background. And yeah, I was taking a breath, as Joyce noticed earlier, because I think before we jump into the details of the guidance, I want to answer the question, and we'll return to this, of why do we care about this? Why are we thinking about this? Is it only Xinjiang? As I think you'll hear, it's actually very, very hard, perhaps next to impossible to rebut the presumption. It's going to be very, very hard if you have inputs that are identified from Xinjiang to rebut that. But the process that is being, the sort of due diligence guidance, the expectations that will be laid out are things that I think companies should start looking at more broadly than Xinjiang and start seeing how they can put in place those requirements. Outside of Xinjiang, there may be similar expectations for policies and procedures, but not the clear and convincing evidence standard, or not the sort of CBP disbelief in third-party audits that make it so hard to rebut the presumption. But the other elements will still be kind of increasingly expected. So I just wanted to set the stage there. And let's see here, we've got a question. Let me see if I can address this. So is the UFLPA actually being enforced? Have goods from China been rejected? We don't have like real reporting on that, but I believe that anecdotally, yes, that is the case. And certainly, even before it came into effect, there were a number of WROs that targeted certain known high-risk commodities from Xinjiang that led to thousands and thousands of entries being blocked from that region. So yes, they are enforcing it, and I think you'll see that continue to ramp up as the processes work out. So to request an exception, which is the same thing as rebutting the presumption, they call it requesting an exception. Some of the things that you will need to do is you'll need to show that your program meets the requirements in the DHS strategy guidance, the due diligence system, which is essentially another word for compliance program. Like you have to show you have a compliance program. Effective supply chain tracing, which is, I think, something that for some supply chains, very little happens. For some, like in the apparel and textile industry, I think it's extremely robust. So effective supply chain tracing and supply chain management measures, you need to have those programmatic components in place. And then for the specific entry that, may be subject to a CBP action, you are going to need to show by clear and convincing evidence that it was not made from forced labor. So even though like the component might be from Xinjiang, then it didn't involve forced labor. And you're going to have to respond fully and completely to all CBP inquiries. And we emphasize that because that's actually part of the statutory and regulatory requirements. So being responsive is actually one of the specified requirements, not just our advice. Next slide, please. We're going to go into each of these in more detail. So the first one, which I think is the piece that, again, I think big picture, companies should probably start thinking about this and how they can put this in place, not just because of the UFLPA in Xinjiang, but because this is a growing expectation from many different angles. Due diligence system, AKA compliance program. What are the elements? Risk assessment. So looking at your supply chain, where the goods and materials that really pose a risk of being made from forced labor are. I think that I may be getting ahead of myself on the slides, but if you look at, for example, the Department of Labor's website where they show goods, they have a list of goods at high risk of forced labor by country and type of good. If you look at the ILO indicators and apply them to your own supply chain, to key suppliers perhaps. If you look at other news sources, and Joyce, throw out any ideas, we can circle back to best practices. These are all ways that you identify inputs that have high risk, and you kind of start to map out your risk and think about the supply chains that have higher risk of forced labor than others. The other component is engaging stakeholders and partners, engaging with your suppliers on this issue, engaging with producers of raw materials on this issue, of trying to identify problems, and also just trying to educate them, get their input, get them on board with the program. having a code of conduct. This is a written code of conduct that applies supply chain standards down through your supply chain. This needs to be incorporated into supplier contracts. And again, this is from the guidance that DHS put out. So when we say it needs to be, I mean, this is what they, that they expect. But these are things to think about more broadly. Communicating and training across the supply chain. So your employees and agents who are responsible for selecting suppliers have understanding about how to identify forced labor and how to educate suppliers and make requirements. Communicating the code to, some of the workers within the supply chain and the trade unions and to the suppliers themselves is part of the guidance. Monitoring compliance, especially once you've done your risk assessment and you identify high-risk materials. Having a system for monitoring compliance with this is part of the guidance. What exactly that looks like is, again, probably a risk-based approach. Remediating violations. This is an interesting one where if forced labor is identified, DHS expects to see that not only are the inputs that have those components produced with forced labor stopped and not entered into the United States, but a corrective action plan is put in place, especially if you're intending to continue to work with the supplier or if you're resupplying, whatever the corrective action plan is, they intend to see that documented. Independent review, this kind of goes to monitoring compliance. The guidance talks about how, the effectiveness can be verified by an independent third party. One of the issues that makes the UFLPA so difficult to actually rebut the presumption is that CBP has been very upfront, DHS has been very upfront, that they don't really believe that independent third-party audits in Xinjiang are plausible because the access of the auditors is so restricted. Many people have reported that they can't really even get auditors to agree to do an audit there. And even if they do, they don't think it's really credible. So that's one of the difficulties in Xinjiang in particular, but it's still a part of the due diligence system. Reporting performance and engagement. This is another interesting piece. So, if you're building on a program and keeping with this guidance, there's an expectation by DHS that you're going to put this out there somewhere publicly. Now, not like confidential information. They say not disclosing business confidential information, but they do expect some sort of public reporting on the due diligence process that you have. It could be in your annual report if you're a public company. It could be sort of a web-based update in your ESG report. They're not really specific about where it would be, but that is a component. So just thinking about the documentation of the system, if you were to try and demonstrate that you have it, you want to have documents that show the supply chain mapping and risk assessments, documentation of your communication with your suppliers and stakeholders. That can be like emails, it can be training sessions, it can be web portals, showing that you've sent your code of conduct to them. They want to see the supplier code of conduct and they want to see where it's flowed down to the suppliers and lower tiers. Training, document the training that you do, like the material itself and the and the records of who received the training. And something, that we see in other areas, I don't actually recall if it's in the guidance, Joyce, maybe you do, but more of the regulators are now indicating that effective training should have some kind of assessment. So you'll see those training sessions, then you get like a little, quiz at the end or something like that. So that's always a good tip if you can get that in there. Monitoring records, you want to show some sort of record that you either from a third party, from your internal quality team, or whoever is responsible within your organization for monitoring compliance. Make sure they show that they're doing this and checking it. And then if you have the third-party independent audits or assessments, records of those as well. So we talked about the first of three elements. Second one is supply chain tracing. And this is an important one because when we talk about demonstrating that something is outside of the scope of the UFLPA, which is potentially achievable, more so I think than the rebuttable presumption is achievable, this is the element you're going to need to focus on. And that's supply chain tracing, which means like mapping the supply chain from the raw materials to your product and being able to demonstrate the chain of custody. So I think we have, more details in the next slide. So, you want to make sure you're focusing on all stages of production, down to the mining, the growing, the manufacture and production steps. You want to be able to show what entities and facilities are involved in these operations. And next slide. You'll want to have information about like the payment records and the shipping records and the inventory records. So you're showing that, you're literally tracing the good from step to step. They do mention in the guidance that sometimes items are commingled. Raw materials might be commingled at a certain facility, but if that's the case and you can't really trace, which good you've got going from this, this step to this step, then you need to be able to show that all of the goods of that type that go to that facility meet this standard. You want to have the information about the contact information and, production orders. It's quite rigorous. And at the same time, it is, I think, we have seen instances where sort of pre-UFLPA, but under the Xinjiang WROs, they were enforcing essentially a very similar standard, similar expectations. And we have seen instances where importers have produced the documentation. CBP has permitted entry of the goods. We've seen instances where there's even a determination that certain manufacturers, their goods haven't been produced from forced labor through this sort of documentation. So it is happening. It is possible. Next slide. So then supply chain management is the third component in the DHS guidance. And this, in some ways, is a bit of an amalgam of the first two components, I think the compliance program and the tracing. But it shows that, beyond, putting things on paper, beyond tracing goods, you're kind of digging into the suppliers themselves, vetting them, having a record of corrective action, and having a plan in place if there's the suppliers fail to take corrective action, which could mean stopping orders, finding a new supplier, things like that. It also includes sort of showing that you have access to the documentation you need and the personnel and the workers within the supply chain. Again, that you've trained your personnel, the indicators of forced labor, and the indicators, that's like the 11 things that was like slide 3 of this PowerPoint. And those, I'll just pause there for a minute. I don't want to underrate training personnel and indicators of forced labor, because many companies have personnel who go and visit facilities regularly for reasons unrelated to forced labor compliance. Often quality and sort of production issues is the reason that they're going there. And, those can really be a force multiplier and useful tools to, training them can be a useful tool at identifying potentially problematic suppliers. I think next slide. Again, if you're doing all this work, you want to make sure you document it. And that means that you want to have the procedures and you want to have the records of visiting the suppliers and asking questions and doing an assessment. Let's see here. We have a question about denied party screening processes and how to involve that. So I think that typically denied party screening, has a big pool of entities that are listed, can provide some information. So some of the companies that are problematic are listed on sanctions lists, like XPCC, Xinjiang Production and Construction Corp, I think it stands for. There's also a new UFLPA entity list, which provides a list of companies that have been recognized as involved with forced labor in the Xinjiang region. Your screening procedures might, include that list as well, and that is important. But it's not going to be sufficient, because it's not going to, most of these screening processes aren't going to be able to identify whether or not a company is in Xinjiang. So unless you have like the address for all of the suppliers and you're searching the addresses, the typical procedures for denied party screening aren't going to capture all of the problematic suppliers. So it's a useful step, but not, I would say, sufficient. Next slide, Joyce, please. And then I think I was going to turn this over to you here, right, Joyce? So we can.
Yes, I can talk about this quickly. Yeah, no, and that was a great question about the denied party screening, because as we'll talk about a little later, when we're kind of putting this all together and seeing, how, like, what companies could actually do right now, leveraging parts of your current compliance program and what you're already doing for KYC, for Know Your Customer, and kind of expanding that and plugging it in with other risk-related assessments and procedures specific for forced labor are going to be very helpful. And then the last, or the second to last, I definitely don't want to skip over the what Francesca previously mentioned, that you also do have to be responsive to CBP, even though there's not a separate slide for that. And we've seen CBP deny entry based on lack of responsiveness, so that is certainly important. With the final element here for rebutting the presumption is providing that clear and convincing evidence that the good itself, originating from the PRC, from China, was not produced, manufactured, or mined wholly or in part by forced labor. And this probably just piggybacks on, it's pretty much an application of all of the programmatic elements that Francesca just discussed, and applying them specifically to the entry that is at issue. So what is clear and convincing? It's going to be more than a preponderance of evidence, if there's any lawyers in the audience. So you have to convince CBP that it's highly probable that the goods were not produced in whole or in part from forced labor. This includes providing evidence of that supply chain mapping, all of the details in there, including the names and contact information of all the entities, the facilities, the operations, again, through all stages of production, really following along the chain of custody with respect to the raw materials, the components, and finally to the finished good. That the supply chain management measures were in place. Francesca mentioned the importance of the forced labor indicators, essentially showing that there are none, or that none were found within the supply chain, but also if they were, whether they were fully remediated or not. And finally, of course, that no involvement at any stage, and this is where that denied party screening piece comes in, that you can show that there's no involvement in any stage of the supply chain to any of the any of the entities on that UFLPA entity list.
And that is involvement outside of China. And so the companies on that list, if they're involved in a different location, it still brings them in with scope of the UFLPA.
Yeah, that's right. Yeah, because if you look at the entity list, it's not just going to be those entities that are on the list, but also subsidiaries, sometimes affiliates, and those might actually be outside of the Xinjiang region of China and in other areas of China. The documents that you have to provide, again, very high rigorous evidentiary standards here. You want to essentially go through the map of the supply chain with all the information that will include all the documents that Francesca mentioned, but specific to the import, purchase orders, inventory records, factory records, bills, shipping documents as well, bills of lading, things of that nature. And finally, in addition, they're gonna want to see information about the workers at the location where the forced labor is not happening or supposed to not be happening. So recruitment practices, the payment of wages, how that's happening, production output per worker, that they're there voluntarily, and again, similarly, that none of the forced labor indicators are there, including credible audits, which, as Francesca has mentioned and has been a topic of discussion, and it's included in the DHS guidance and elsewhere. Very difficult to obtain credible audits in the Xinjiang region that CBP will rely on. And we also wanted to highlight the high-risk materials that have been the target of enforcement and that were included in the CBP Operational Guidance at Appendix A. They go through additional documents that might be required for these types of products, for products that use any of these products in their supply chain: cotton, polysilicon, and tomatoes. They've also added and focused the DHS guidance, even though they didn't provide the types of documents. They added textiles as well and hair products. So there's more information on that in the DHS guidance that gives you kind of a preview potentially of other high-risk materials that they will be looking at. But as you can see, it's just way more and more detail. Tomatoes is a good example here, not just records of the tomato pressing facilities, but also even of the tomato seeds and all entities, and they want flow charts of this type of information.
So Joyce, we have another question about the entity list, and then I think a question I'll hold till later. But the question is the UFLPA entity list included with the consolidated list that Commerce releases for screening, that includes state and OFAC and BIS lists? And I don't know the answer to that, but I think when I last checked, I don't think they'd updated it when I last checked. So I think you would need to like a week ago when I was looking at this, I think you had to still manually go to the entity list yet. I don't know if they've updated it yet, but
I'm not aware that they've updated the US consolidated list search with that list of entities. So you will have to kind of just manually go in and take a look at it. It's available on the website. It's also in the DHS guidance if that's easier, but it's tricky too because some of them say subsidiaries like Hine, and I'm sure many folks are familiar with that WRO. And it wasn't just the Hine entity in China, but also all subsidiaries as well. So it requires additional digging, not just outside of the consolidated list, but also additional due diligence to find, where these subsidiaries are and who they are. And then we just wanted to briefly touch on this section, even though it's probably the section that importers might actually be able to provide sufficient information more likely than to rebut the presumption, and it's out of scope request. This was kind of, what is the word I'm looking for? A little bit buried in the DHS guidance and the CBP guidance. But it's interesting, and they didn't spend too much time on it, but I think it's worth talking about here. If your imports or your entries are somehow caught up in CBP enforcement, in a CBP enforcement action, and they are made wholly outside of Xinjiang region, and they don't involve any of these entities on the UFLPA entity list, there is an option to respond to CBP through a request that we make an out of scope determination, essentially by providing information that you have successfully, or at least effectively, engaged in supply chain tracing. So you've mapped sufficiently the supply chain, and that's part of your due diligence program. And also that specific requirement that you've also met that for the particular good that you're importing. So you not only have that as part of your supply chain compliance program, but also that you're able to map the source of the goods outside of Xinjiang region. It doesn't say that you have to show that it wasn't produced with forced labor. It says that you have to show that the goods were produced outside of Xinjiang. There's no evidentiary standard for that, but we assume that it's not going to be as high as a clear and convincing standard, but we can talk about what that actually practically means.
And just to make sure it's clear that if CBP alleges, with some evidence that it was made from forced labor someplace else, then those are also subject to an import ban. But if the reason it was detained is that they thought a component or raw material came from Xinjiang, then the way you would show it's out of scope is by focusing on the fact that it's not from Xinjiang. You don't need to necessarily pull in all of the other forced labor.
Right. No, that's a good point. Yeah, just because it doesn't fall within the scope of the UFLPA doesn't mean that it wasn't potentially produced in whole or in part through forced labor and might still be denied entry into the United States based on other risk factors and other regions.
Yeah.
All right, now we get to talk about UFLPA compliance and what the practical considerations are, what we're seeing our clients, industry struggle with. You want to talk about this?
Sure. So, one of the sort of practical considerations, we've already touched on is, can a company actually rebut this presumption? Or realistically, are you going to be looking at shifting your supply chain? And my experience is that it's more likely you're going to be looking at shifting your supply chain, because the clear and convincing standard, the clear and convincing evidence standard, the lack of belief in the credibility of audits in Xinjiang, all of these issues make it very difficult to meet the rebuttable presumption. But that said, I don't think that means companies shouldn't look to that guidance and be putting those pieces in place. I mean, many of them will help companies with supply chain tracing, supply chain management. And I think that, this is may well become a standard that is applied in other circumstances. So I think companies should start really looking at the components of the program and figuring out how they can start putting them in place, while understanding that for the UFLPA, it's going to be pretty tough to meet the rebuttable presumption. I will be curious. CBP is required to report to Congress anytime that they determine that the presumption has been rebutted, anytime they grant an exception. And I'll be curious in 3 months to see if that's happened. I don't know if you want to do next slide, but we do have a couple questions. And while we're talking about this, one of them was, is there any indication that CBP has looked at any silicon-based products beyond solar panels? And I do think that CBP has certainly indicated that they're looking at components that include silica. I'm not aware off the top of my head of any sort of public findings that something was not sourced from forced labor. I do know that there are solar companies that have successfully obtained CBP determinations that their solar panels weren't made, including Chinese companies, that their solar panels weren't made using silica that was produced from forced labor. But I'm not aware of any sort of surfactants or chip type silica determinations. Joyce, I don't know if you have any that come to mind.
No, that's right. There aren't any other finished products that based on silica that have been specifically targeted. But I will say that the prior WRO that has to do with Hine, if you look at the wording of it, it says all silica-based products, so it's pretty broad. And if you dig into Hine and their subsidiaries and their affiliates in the region, they do produce raw materials, not just for the solar panel industry, but for other industries, including what you just mentioned, Francesca, for surfactants and for other like construction industry and other related industries as well. So I wouldn't necessarily assume that just because the finished good hasn't been targeted yet, that it won't become an issue, or that they won't get, you know, fall within the scope of the UFLPA.
Right. We have another question about whether the out of scope determination, if you're seeking that, whether you have to show that the finished good or all of the steps in the supply chain were not conducted in Xinjiang, and it's the full supply chain. So if CBP believes that there is a raw material sourced from Xinjiang, and you are trying to demonstrate that your product is out of scope, you'll have to go back to that raw material. Another question earlier that maybe we'll just touch on now is whether non-US companies that work with companies on the UFLPA entity list or companies in Xinjiang might be targeted for sanctions by the US. Right now, I think that we haven't seen that, but certainly we have seen companies in Xinjiang added to the SDN list. And that was in the sort of guidance from a couple of years ago for human rights violations. And so it is possible that a company that was working with a company engaging in human rights abuses might itself be targeted, but we haven't seen that, and I think it's a little tenuous. Supply chain tracing. Sorry, Joyce, it's giving you headaches today. So some sort of practical considerations there. Again, and supply chain tracing is relevant to out of scope and rebuttable presumption. It's practical considerations are, can you really get the document in a timely fashion? And most companies don't keep purchase orders and vendor documentation and shipping documentation from their supply chain on hand, unless you perhaps have a very high risk item or something that has been subject to detention before. That's not necessarily something that you gather. So thinking about how quickly you can get the documentation if you need it, whether you need to start working with your suppliers to understand what they would need to produce, what the timelines are, and what the consequences would be if they aren't reliable and they don't provide the information you need. I think that's a critical consideration. Data integrity, that's another consideration. I don't know if you want to touch on that a bit, Joyce, but
yeah, I mean, traditionally, reliance on certificates of compliance and affidavits, which the affidavits themselves are included in DHS guidance as documents that importers are expected to show with respect to supply chain tracing. But whether or not those are reliable, similar to audits in the region, we'll see. We'll see what importers are able to show based on those published reports that actually satisfies CBP. So there's an issue potentially there, and then these two categories of issues that we're seeing clients and industry struggle with are even more complicated through complex supply chain and products. And those are some examples of that.
We have a question about, and this segues nicely into our final discussion topic, future of supply chain due diligence. is, do we expect CBP to apply a similar evidentiary standard to other goods subject to WROs or other findings related to forced labor now that UFLPA is being enforced? You know, on one hand, the evidentiary standard is in the statute, so it has its own source, and so in theory, they would not apply the same standard. In practice, I think the nuance of clear and convincing evidence versus, you know, preponderance of the evidence is going to be difficult for CBP agents to distinguish. So I think that we might see an overall increased expectation and sort of like what the evidentiary, what evidence you need to provide, how clearly you have to make your case. I don't know if you have any different thoughts on that, Joyce.
Yeah, and another point would be that, and I agree with you, and I think the clear and convincing standard is going to be looked at by CBP across the board in a similar way, and it is tied to the supply chain tracing and supply chain management programmatic requirements, right? So you're essentially proving that for that imported good, you applied all of these program-specific elements. So I agree, it's just going to be hard to distinguish between this standard and any other, you know, clear and convincing evidence standard that is out there.
Yeah. Okay. So we are running short on time. We may go over a little bit, but I want to try and get through the slides at least by 3 o'clock. So I'm not going to talk about this one again. You've already seen it. Things are getting tighter. We've already talked about this, but I guess I will circle back to the fact that it's not just the United States. For companies that are active in other jurisdictions, especially the European Union, there are requirements coming into effect that come at this issue from different angles, but will require some of the same supply chain tracing, some same due diligence steps. I think we didn't really talk about leveraging different, oh, that's best practices. Gosh, we have one more section. Okay, I'll be even quicker. Increased expectations. Next slide. So what steps can companies take right now? And this is sort of aligned with best practices. So, you know, really start thinking about risk. Whether or not you think you have items in Xinjiang, start thinking about your forced labor risk. And the question of whether or not you have supply chains going back to Xinjiang is one of the risk questions you should be asking yourself. Do you know where their goods and components are made? Do you know what regions pose elevated risks? I've stopped being surprised, but I used to be surprised when I would dig into this, that a lot of the, you know, engineering, development, production folks actually have an excellent understanding. Like if you showed them the list of products that have a high risk of, you know, forced labor, it's not actually really hard for them to figure out if their products have those materials in them. So if you're coming from compliance or legal side, you might not realize that your resources are as good as they are internally to identify risk. And do your employees understand red flags for child and forced labor? So they can flag for you. They can be your boots on the ground and flag for you issues that you may not have identified from your top-down risk assessment. And just understanding who your key players are in your supply chain. Next slide. You know, again, similar theme. Do you know if you have any goods that are going to be within scope? And if you have goods within scope, you know, definitely start focusing on whether it's even plausible to, you know, rebut this presumption, or what you should, you know, be doing to think about how to organize your supply chain. If you have goods like that use high risk items like silica from China or cotton from China that's not from Xinjiang, or as far as you're aware, it's not from Xinjiang, but it's a high risk item coming from a high risk region, there's a good chance you might get caught in a CBP enforcement of UFLPA. you're going to have to make an outside the scope argument. And can you trace these goods and show document support? You know, that's a start. And then taking a step back and looking at your compliance program, do your policies and procedures align with the due diligence system? And if not, how can you sort of step by step start building that? It's not the kind of thing that's going to be built in a day or a month or probably a year, but you can start moving the pieces in place so that you can gradually get to the where you want to go. And as we mentioned, when you're doing this, there's probably a lot of elements within your company, a lot of existing diligence that you can incorporate into your program. If you're in CTPAT, you have a whole list of inquiries and diligence you conduct with respect to your suppliers within your supply chain, and you can weave some of this in. Sanctions diligence and anti-bribery diligence are resources that you can start using and maybe tweaking or expanding the questions asked, or the tool, the desktop diligence, conducted. You start tweaking that to include this area. Looking at alternate sourcing and routing. So if you have high-risk items and you think it might come from a problematic country, are there other alternate sources? Are there suppliers who have demonstrated that they are committed to mitigating forced labor, and so they've done a lot of the legwork for you? If you have any entity list entities, what's your plan for dealing with that? So yes, thinking about sourcing and routing. And then next question. Then we have a few. Oh, I think we just went over 3. So let me quickly give the CLE code for those of you who people had to drop off. They can email us, but it's CLE for today's program code is FL7119. Again, the CLE code is FL7119. And we're going to keep going and answering questions. Can you, we'll skip over this. It's a bunch of great resources. Last section is questions, and we'll chat about best practices. Okay, so the code is FL, F as in forced, L as in labor, 7119, in case it was not clear. And then we had a question about electronics and aluminum alloys.
So those, yeah, sorry.
Go ahead, Joyce.
Yeah, no, they were mentioned specifically, those 2 items as high-risk materials that have been linked to forced labor in the Xinjiang region of China in the DHS strategy guidance. So that's certainly something to be aware of, and it's really important, in the last slide, to utilize these available resources, even if it's just a control find in the DHS guidance, to look at whether or not they mention the product and how to kind of elevate your resources and risk assessment to target those specific items. And they may be caught in the UFLPA enforcement because they've been linked to the Xinjiang region, they've been linked to forced labor.
Thanks, Joyce. We have another question about sort of what would be considered acceptable proof that neither the good nor the raw materials were produced in Xinjiang. So I think, one thing that that question raises for me is just to emphasize, when we look at forced labor, when we looked at that map at the beginning of where forced labor is happening, most of that is related to raw materials. So it's actually kind of rare that a manufactured good is being stopped because they think the person who manufactured that good was using forced labor. It's because of the upstream, downstream, the inputs, the raw material inputs. So when we talk about supply chain tracing, you're going to need to be what's acceptable proof is going to be a supply chain tracing back to whatever that raw material was or other, perhaps processed input was. And that, goes back to our slides about what is supply chain tracing. And that's going to be just the purchase record, inventory records, the shipping records. I mean, really very rigorous tracing of the good, all the way back to raw materials that were not sourced, not produced with forced labor. It could be a different stage in the process where the forced labor comes in, but often it is the raw materials or the very initial stages of processing. Let's see. Okay. Any other best practices while I skim through, see if we've got unanswered questions, Joyce, that we didn't really have a chance to highlight as we were speeding through our presentation?
Yeah, I think if we're trying to predict a little bit, looking at our crystal ball, there's going to be certainly a huge, more and more expectations for suppliers to gather and provide this type of data. So thinking through what that looks like in terms of your code of conduct, your supplier code of conduct, requiring certain changes, certain record keeping types of things. I think that's something that is going to become more and more expected and rigorous. And the group of suppliers, manufacturers, and producers, farmers, growers that have this type of information available are going to be, chosen over the other ones that do not. If we're looking, this is more 3 to 5, 10 years. So preparing for those kind of increased standards, evidentiary standards in general.
Right. And I think, as you said, kind of predicting the future, I do see some parallels here with conflict minerals. And you already see it in certain industries. People kind of coming together to produce ways to provide rigor and supply chains of certain materials in a collective way so they can try and be efficient, and not every company has to do all of this itself or invent the wheel. So you might see more sort of either certification programs or just collective efforts like that. There's also some interesting things happening, which the guidance actually mentions, involving trying to use technology to trace some of these raw materials, with even like DNA markers for things that are, organic raw materials, tracing them from certain sources. So there are some technological, innovations out there. And unfortunately, we're out of time, so we can't talk about them, but I'm always happy to hear about them. So if, and someone did mention the USDOL Sweat and Toil app, and whether the UFLPA entity list is on that app. I don't know the answer to that. I would have to check that again, but I'm glad someone mentioned the app because it's a great tool. We mentioned the Department of Labor has a list of resources for, like, these are the raw materials, or lightly processed materials that have high risk of forced labor. And so it really helps you focus your resources. So that's a great tool to use. I'm not sure they've updated it. If they had, by the way, it was very recent that they updated it to add the entity list, but I don't think actually that it's on there yet. I don't see any other questions. So I think I will just repeat the CLE code one more time. It's FL7119. And also, if you are not currently receiving our updates and invitations, please go to thompsonhinesmarttrade.com. You can subscribe to our blog, and then you can get like kind of daily updates as we see developments, not just in forced labor, but covering all manner of trade issues, free trade agreements, sanctions, export controls. And thank you for your interest in attending today's webinar. Enjoy the rest of your day and stay well. Bye, everyone.
Bye. Thank you.